All right. Good afternoon, everyone. Welcome to the DocketWise webinar on the state of the immigration court, reflections from a former immigration judge. I'm James Pittman, co-founder here at DocketWise. I have with me former immigration judge Charles Honeyman. Many of you will already know him. Charles Honeyman was an immigration judge in New York and Philadelphia for 25 years. He's a graduate of University of Baltimore School of Law, practiced immigration law in Baltimore and Philadelphia. I've certainly had cases in front of him, and I'm sure many of you have as well. He's going to present a 1-hour presentation on the state of the immigration court, and I'm going to ask you, please do feel free to utilize the chat function on the right side of your screen. We do want a lively chat going. However, for questions, I do want you to use the Ask a Question feature at the bottom, and then also feel free to upvote questions. After the 1-hour presentation, we'll have about 30 minutes of questions and answers, and I'll be attempting to ask questions in the order of their popularity. So if you upvote questions, then I can see which questions are most popular. But with that said, I'm going to turn over the floor to Judge Honeyman, and let us now have him take it away. Charles, go right ahead. You're on.
Okay, thank you. Welcome to everyone, and thank you to DocketWise and its co-founder, James Pittman, for inviting me to present this webinar, during which I'm going to offer my reflections and current insights as a former immigration judge relative to the courts and the Board of Immigration Appeals and various policy issues. As you undoubtedly know, immigration law has been, and it's even more true today, subject to ongoing volatile regulatory and policy changes, as well as periodic statutory changes. Plus, particularly since 2002, exploding jurisprudence from the circuit courts, all of which, and most particularly recently, the Board of Immigration Appeals, have been infected by ever-changing political winds and shifting alliances. We begin today with my journey and its historical context paralleling 4 decades of developments in the field of immigration law. Along the way, I'll examine structural flaws inherent in the executive branch position of both the court and the board, and thus attempting incentives that consequently exist for politicizing appointments and management initiatives. Springing from this now widely held recognition, there are proposals for significant structural changes to include the creation of an Article I immigration court. Next, I'll take a look at the Attorney General Certification Authority, no longer just sparingly used, at least by this administration, in its frantic, nationalist-inspired race to rewrite and reverse the landscape of well-settled precedent, exposing what some have called a Supreme Court of one. I'll mention some of the critiques of such seemingly unfettered authority and whether such AG decisions should receive Chevron deference. Thereafter, I'll offer some commentary on the likely impact of pending regulations on litigation in the immigration courts and the board, as well as the management of dockets within those institutions. We'll wind down with some commentary on the impact of COVID-19, including challenges, safety, diminished due process, and the lack of transparency. And lastly, I'll leave you with some personal thoughts about the factors that motivated me to retire as an IJ and return to teaching and advocacy and of counsel work in support of due process. Hopefully our time together will likewise motivate you and your staff to maintain and enhance your dedication to the very highest levels of advocacy and professionalism at a critical moment in our history when it is truly needed more than ever. My journey to immigration law and the bench and how this integrates with the history. My journey begins in 1980 in Baltimore, clerking for a firm that decides to start an immigration practice. Prior to law school, I had degrees in political science and public policy and knew quite a bit about government, having interned for a federal agency and served in the mayor's office in Baltimore, but I knew very little about immigration law and policy aside from the recent initiative within the Department of Justice to denaturalize former Nazi war criminals. In 1980, there were just 17 law schools in the United States that offered an elective course in immigration law. Moreover, nationally, there were only 1,000 members of the predecessor organization to the later renamed American Immigration Lawyers Association. Working on cases as a clerk and then a young attorney, I read all the statutes and the basics of the law, and it looked like there were just so many gaps to be interpreted by agency officials. Sometimes I felt as though there was a book missing, or various components of the law had been thrown together and either made little integrated policy sense, or were the product of lobbying by interest groups with particularized agendas that made the overall puzzle, shall we say, puzzling. This was particularly true when I read about the labor certification process. Ultimately, I joined AILA's DC chapter and learned, as many of us did back then, through welcoming collegial exchanges, CLE conferences, and annual conferences, which I began attending the AILA conference in 1983. My early experiences quickly convinced me that I had found a rewarding professional home in the field of immigration law, impacting grateful individuals, families, and businesses, as well as finding a family of friends in the AILA DC chapter and later in Philadelphia. And there was an increasing political sensitivity to immigration law and attention, leading to the 1980 Refugee Act, 1986 IRCA statute with its legalization, citizenship discrimination, and employer sanctions provisions, and the more expansive Immigration Act of 1990. On a personal level, my trial level court experience grew, my AILA involvement increased, leading to 2 years as national co-chair of its liaison committee with the OIR, while teaching as an adjunct at Villanova Law School for 2 years. And then the opportunity that ultimately drew my attention in a different direction, being invited to speak at the 1990 Immigration Lawyers Conference, the Judges Conference in San Antonio. That experience sparked my interest in becoming an IJ and set forces in motion that in September 1995 led to my appointment and beginning as an IJ in New York. My investiture, along with 8 of my soon-to-be colleagues, began a more than 24-year journey, rewarding as immigration judge, the last 18 of which in Philadelphia. Now, as an immigration judge, I had many challenging, legally complex, and yet always impactful experiences, handling mostly the non-detained docket in Philadelphia, but also the Pittsburgh televideo docket, prison details, special assignments such as Nazi war criminal cases, and seeing with lots of gratitude the publication of some of my decisions after appeals in the circuit courts in the 3rd, 1st, and 2nd Circuit. I enjoyed being a teacher, a faculty member of AILA CLE conferences, and particularly my involvement with the National Association of Immigration Judges. This all ended in January of 2020, this year, when I decided to retire. More about that at the end of my presentation. Structural flaws, political incentives, and the growing support for an Article I court. Previously housed within the former INS, the modern immigration court comes into existence in January 9, 1983, as a component of the newly created Executive Office for Immigration Review. While remaining within the Department of Justice, the rationale for this new component was to ensure a greater degree of separation structurally from the DOJ component, then INS, that prosecuted foreign nationals by initiating civil removal, previously known as deportation proceedings. March 2003, the various components of INS were merged into what is now DHS, while EOIR remained within DOJ, but thus still under the direct supervision of the Attorney General of the U.S., a political appointee, and the nation's chief prosecutor. As a consequence of this awkward and some would say illogical structure, DOJ appellate attorneys will defend IJ decisions in federal court when benefit applications are denied, and foreign nationals are ordered removed after a BIA affirmation. But conversely, those same DOJ attorneys will argue to defeat IJ grants of benefit applications in federal court if DHS prosecutors appeal and the board reverses such grants. Because DOJ may both defend and urge the reversal of IJ decisions, this taints the immigration court as an entity far less independent, less impartial, and apolitical than any court anywhere. In fact, despite IJs having statutory and regulatory authority to be designated as judges, presiding over immigration courts, The DOJ internally treats IJs merely as agency attorneys, with all the limits and constraints that imposes. As a result, a large number of sitting and retired IJs, including their legally recognized collective bargaining representative, NAIJ, have advocated for structural reform through the creation of an Article I immigration court. The authorities for such creation would be similar to that which resulted in the establishment of the tax and bankruptcy courts. Beyond avoiding the appearance of bias in decision-making and docketing priorities to both the left and the right of the political spectrum, depending on who occupied the White House, such structural reform would inevitably lead to a more stable budget, commensurate with the evolving needs of such an independent court. And after a period of grandfathering, there would be opportunities that would exist for the ongoing appointment of a sufficient number of qualified trial level and appellate judges to meet the changing needs of the court. Such an independent court model, with a firewall between it and the executive branch political appointees, once the court was formulated, would also shield IJ decisions from criticism by federal courts, litigants, the press, and the public, that some decisions seem over time to reflect a lack of impartiality. An example of such an area of concern is the perplexing and disturbingly wide disparity between asylum grant and denial rates among different judges and courts and within courts. These disparities have raised a concern that some decisions might be tainted by political considerations, predisposed bias, and not so subtle internal bureaucratic pressures from those within DOJ who control the budget, the appointment power, and the power to discipline and possibly terminate IJs whose decisions do not align with the policy preferences of a particular administration. And this could happen under administrations on both sides. These concerns have been heightened as a result of the IJ quotas and performance metrics that became effective October 1, 2018. Moreover, the overwhelming dominance of recent IJ appointees with prosecutorial, law enforcement, and military backgrounds, to the near exclusion of those from private practice, is another area of concern. Among the more egregious examples was the July 2020 announcement by Attorney General Barr that he had appointed Matthew J. O'Brien, who had spent the last 4 years as research director of the Federation for American Immigration Reform, FAIR, to a judgeship with the Arlington Immigration Court. Several former IJs and others have told media outlets that O'Brien is not qualified for the job due to his outspoken advocacy for FAIR, which the Southern Poverty Law Center has classified as a hate group in light of its leaders' ties to white supremacist groups. Moreover, according to SPLC, FAIR's late founder, John Tanton, was, quote, the racist architect of the modern anti-immigrant movement, and was associated with other extreme anti-immigrant groups. Moreover, in the same month, Attorney General Barr appointed Tracy Short as chief immigration judge. Most recently, Short served as ICE's principal legal advisor, i.e. chief prosecutor, and senior advisor to the ICE acting director. In his most recent position, an internal memo revealed that Short had urged ICE attorneys to exclude no one from immigration enforcement, challenge grants of immigration benefits more broadly, and narrow the circumstances in which they might choose not to prosecute. Similarly, all recent appointments of IJs to the BIA have had extremely high asylum denial rates, which appear to have been the primary reason for their selection. Additionally, the ultra-conservative leadership of the BIA was solidified when Attorney General Barr appointed David H. Whitmore as chairman. Whitmore was a former immigration advisor to the White House Domestic Policy Council, and he contributed to some of the Trump administration's most egregious policies, including the travel ban and family separation policy. All of this reflects an unprecedented effort to shape and influence the content of decisions through ideologically vetted appointments. Just as remarkable, but perhaps not surprising, in June, an internal memo reviewed by CQ Roll Call revealed that James McHenry, EOIR director, had offered financial incentives to 9 incumbent BIA members appointed by both administrations, encouraging them to retire or resign. No one accepted the buyout offers. Thereafter, these members were reassigned to new roles defined as appellate immigration judges rather than senior board members. And the differences go beyond just title, apparently, and this hasn't all been flushed out. They extend to pay ranges and leave policy. And the other interesting thing is that these appellate immigration judge, and I'll mention it later, can also do trial level cases. And some fear that what they've done is vet out and spin off these individuals and have them do more trial level cases than board cases that might ultimately result in precedent decisions. Now, while EOIR has consistently denied that hiring has become politicized, it is clear to most observers that the administration is both packing the appellate bench and seeking to make room for ideologically compatible judges who will conform to a narrow anti-immigrant interpretation of the law. Make no mistake about this effort, and is consistent more broadly with the administration's political agenda and appointment agenda that strives for and celebrates the notion that all courts, including now apparently administrative tribunals, can and should be transformed into lockstep, purely loyal and politically deferential institutions. Nominal judicial independence as a check against abuse of power is merely window dressing, designed, in my view, to shield, however ineffective, the administration's not so subtle authoritarian leanings from the light of day. All of this and more reveals, along with various regulatory initiatives, proclamations, and executive orders, the unabashed agenda of today's radical restrictionists who now control the immigration policy agenda subject to court intervention. And the courts have intervened against the administration, as you know, on many occasions. In light of this administration's assault on any push for greater independence or true impartiality by IJs individually or through their union, the NAIJ, which, by the way, DOJ has attempted to decertify, and the litigation is still pending, so far unsuccessfully, that IJs are managers. The need for an Article I court is more urgent and compelling than ever. Proposals and even draft legislation have been around for many years and admittedly would be a complicated undertaking. But support is growing among many institutions, including the American and Federal Bar Associations, AILA, the American Immigration Council, and even the right-leaning Cato Institute, as well as more and more within the political class. Such support has taken hold, in particular, because of the administration's harsh and economically indefensible anti-immigrant policies. Moreover, the administration's efforts to control, micromanage, and reshape both the structure and composition of the courts and the BIA have been unprecedented and disturbing to many observers. While an Article I court would serve both due process and be in the best long-term interest of both political parties, it is generally agreed that its prospects for passage are tied to an ultimate agreement on a comprehensive immigration bill within which such structural changes would be a component. Next, the Attorney General's obscure certification authority, a Supreme Court of one. Another of the unprecedented and disturbing developments has been the Attorney Generals of the Trump administration, all three of them, broad rather than sparing use of the statutory regulatory certification power to rewrite BIA decisions. This expansive use has been one of the critical strategic steps in the conscious and deliberate plan by White House advisor Stephen Miller in collaboration with successive attorney generals to alter the landscape of immigration law, consistent with the goal of dramatically reducing eligibility for immigration benefits, in particular asylum and related relief. The source of the Attorney General's authority is worthy of some initial review. Under Section 101G2 of the Act, the Attorney General shall, among his other powers, review such administrative decisions and immigration proceedings as the Attorney General determines to be necessary for carrying out this section. Implementing regulations begin with 8 CFR 1003.1 DI, which states, among other things. The board shall be governed by decisions of the Attorney General through review of a decision of the board by written order or by determination ruling pursuant to Section 103 of the Act, which is the statutory anchor. Continuing to elaborate further on this point, 1003.1D7 states, the decision of the board shall be final except in those cases reviewed by the Attorney General in accordance with paragraph H of the Act. Section 1003.1 is the specific regulatory source of this authority, and it's entitled Referral of Cases to the Attorney General, stating in part, the board shall refer to the Attorney General for review of its decision all cases, one, that the Attorney General directs the board to refer to him, the chairman or a majority of the board believes should be referred to him, and the Secretary of Homeland Security or specific officials within DHS designated by the Secretary with concurrence of the AG refers to the AG for review. Utilizing the aforementioned authority, the operational goal is undoubtedly to identify and reverse as many key BIA precedents, such as matter of ARCG in the domestic violence context and matter of LEA in the family context, to reverse or narrow these such that because of the fear that these decisions represent the potential for large numbers of foreign nationals to be eligible for immigration benefits, particularly asylum. This component of the overall restrictionist plan runs parallel to the more complicated and lengthy process of publishing and implementing revised regulations, which likewise would have the goal and effect of reversing well-settled or at least well-reasoned case law spanning decades if necessary. Clearly, the pace and number of AG certified decisions, as well as regulatory initiatives, represents a frantic effort to implement as much as possible while this administration retains power, hoping that the circuit courts and the Supreme Court will give the Attorney General's decisions full Chevron deference as reasonable interpretations of various sections of an ambiguous statute. Now, whether such usual deference will or should continue is likewise worthy of critical analysis and consideration by immigration attorneys who must, on the record, present contrary arguments at the trial level, and if unsuccessful, preserving them for a fresh review by the circuit courts. Such contrary arguments have recently emerged powerfully in well-respected blogs and law review articles and abstracts. And I'll give you some examples of this for your own reference. Chevron and the Attorney General's certification power, 91 New York University Law Review, 271 from this year by Jonathan Riedel, spelled R-I-E-D-E-L. Fight back against Chevron deference in asylum and withholding cases. And the blog is thinkimmigration.org, June 18, 2020 blog, posted by Maureen Sweeney, S-W-E-E-N-E-Y. And she also explored the Chevron issue in immigration decisions in the current AILA Law Journal. Deporting Chevron, why the Attorney General's immigration decisions should not receive Chevron deference. And this is a very important research abstract by Professor Richard Frankel, Drexel University Thomas R. Klein School of Law. And this was posted on December 6, 2019. And perhaps the best overall critique of this summary of arguments against affording Chevron deference to the AG's certified decisions and immigration judges comes in Rethinking Chevron by Jeffrey S. Chase, a personal friend of mine, former immigration attorney, former immigration judge, current immigration attorney, actually, former BIA senior advisor and nationally recognized expert on asylum and refugee matters and litigation matters generally. JeffreySChase.com, February 2, 2020. Chase is particularly persuaded by the analysis presented by Professor Frankel, who distinguishes precedent decisions issued on certification by the Attorney General from those issued by the BIA, and argues that the former should not merit Chevron deference from the courts. Frankel notes the sweeping power of the regulations authorizing such certification placed no limitation on the authority of the Attorney General's review. Attorney General's review authority, as the AG is not bound by BIA precedent, reviews all decisions de novo, does not defer to factual findings or legal conclusions, and can even accept new evidence and make new factual findings. Frankel reminds us that no federal court has directly answered the question as to whether the Attorney General's decisions are in fact entitled to Chevron deference, although seeming to imply the same in some cases. Concurring with Frankel, Chase argues that it would be more appropriate for AG decisions to be subject to the sliding scale deference afforded by the Supreme Court's pre-Chevron decision that many of you are familiar with in Skidmore versus Swift, under which the amount of deference accorded depends on the thoroughness, reasonableness, and consistency of the decision in question. Chase further agrees with Frankel that none of the rationales for such deference cited by the Supreme Court in Chevron and refined in subsequent decisions apply to the AG review of immigration decisions. First, noting the court's mention of procedural formality as a criterion for according deference, Frankel argues that the AG certification process actually removes cases from the procedural formality of the BIA's appeal process and replaces them with a largely open-ended authority described above. Frankel notes that certification actually transfers decision-making authority from those with subject matter expertise and experience, the BIA and IJs, to one lacking such expertise, in his view, the AG, thus undermining a second basis for deference by the court. Lastly, Chase concurs with Frankel that the AG certification process does not meet the final Chevron criterion of public accountability, which suggests that decisions should presumably be made by one who is neutral and exercising independent judgment, rather than one acting out of a motive to advance the president's immigration policy agenda. Alternatively, Frankel argues that where the AG claims, as in recent decisions, to have issued such decisions free of political influence, the justification of political accountability as a basis for Chevron is undermined. Impact of proposed regulations and policy changes. First of all, there's too many to address in this short webinar, but here's my take on the most important ones and ones that are on the verge of being published in the next day or so. While the most important regulatory proposals impacting the court and the board have yet to become final, it is unlikely in this writer's view that the comments received are likely to result in significantly less restrictive language. On the other hand, recent appointments by the Attorney General are likely to have an immediate impact at both the trial and administrative appellate levels. On June 15, 2020, DHS and the Justice Department's EOIR published lengthy, wide-ranging proposed regulations in an effort to revise and severely restrict eligibility for asylum, withholding, and Convention Against Torture relief. Among the thousands of comments to these proposed regulations, and I believe there was over 87,000, urging the rescission, were those, somewhat surprisingly to some, from the union representing asylum officers. The union's position is that these regulations will flout decades of law, dismantle our carefully crafted system of vetting asylum claims, undermine America's position as a global leader in refugee protection, and will narrow the definition of persecution in a manner deliberately designed to deny asylum applicants the protections required by statutory law. Others filing similar comments included 70 members of Congress, the American Immigration Council, AILA, the Roundtable of Former Immigration Judges, of which I am a member, many other nonprofits and private law firms. The theme running throughout these comments is that the proposed regulations are inconsistent and ultra vires with the statute, with the Refugee Act, our various treaty obligations, the overall intent of Congress as expressed by the content of various statutes, and moreover would completely abrogate the decades-long body of case law that has been developed over the last 40 years. On July 8, 2020, as announced by DHS and DOJ, the Trump administration proposed a policy that would allow officials to quickly turn away asylum seekers deemed a health risk and thus a danger to the security of the United States. Once final, which it will be soon, This will allow the agencies to consider emergency public health concerns based on communicable disease findings due to the potential international threats from the spread of pandemics, while determining whether an individual is eligible on security grounds. Under this proposal, officials would consider conditions in the home country, countries individuals traveled through, and evaluate the risk of spreading disease accordingly, and result in quick deportation without the procedural protections of a court hearing. Despite the government's assertions that these are necessary reforms in light of COVID-19 crisis and to ameliorate or even forestall future public health emergencies, this move has been seen by many as yet another pretextual policy, this time utilizing public health grounds to end asylum and other protections under current law. And I should note that this week there have been articles in law360.com and in BuzzFeed addressing the evolution of this regulation and stating that there's going to be a final rule published tomorrow on this issue. There are, I would say, one of the most important aspects of what looks like is going to be a part of this final regulation, and is that there is language in there that would grant the CDC director the authority to expel individuals, not just prevent the arrival of individuals. And of course, there's also lawsuits pending over this, and this would obviously also wipe out or ignore various precedent decisions, our treaty obligations, et cetera. So stay tuned to see how this plays out and the litigation accordingly. So I mentioned the Attorney General several times and the ideologically tainted appointments. So at the appellate level, the Attorney General continues to pack the BIA with hardliners with over 90% asylum denial rates, and former prosecutors, particularly with those that have had some experience or connection to the Atlanta Immigration Court, which is known by many and mentioned in litigation as an asylum-free zone, because there's so very few asylum cases that are granted in Atlanta. The Trump administration has now increased the board's total by 6, with appointees coming exclusively from backgrounds which indicate a likelihood of decisions reflecting extremely restrictive interpretations of the law. Just as troubling was the mention that I noted earlier of the taking of pre-Trump board members and assigning them this new title called appellate immigration judge position. And I mentioned that there's a potential, some are saying that there could be a conflict of interest here, and others believe it's a not so subtle move to demote members who will be increasingly assigned to hear trial level cases and perhaps not be involved with precedents. And shockingly, as often is the case with this administration, the attempt to rationalize what is going on at the board was reflected in comments by an EOIR spokeswoman who explained to CQ Roll Call that the reassigned board members, now appellate immigration judges, include, quote, individuals whose positions will help us strategically restructure EOIR in order to accommodate skills, technology, and labor markets. This Orwellian explanation to me makes no sense. It's almost like the words were taken out of a hat. Whether these were demotions or something else may be somewhat unclear, but they certainly have nothing to do with labor markets, and were more likely ideologically driven changes euphemistically characterized as reassignments. In addition to the changed composition of the board, on August 26, 2020, DOJ EOIR published a comprehensive 88-page proposed regulation that dramatically alters much of the administrative appellate process, impacting IJs as well. Under the guise of merely speeding up appeals, the proposal is just so much more. Among other things, it is an assault on, and I believe a warning to circuit courts that have dared to defy the Attorney General by validating the authority of the BIA and IJs to administratively close cases, either unilaterally or with the consent of the parties, and generally manage their dockets. With a stroke of a pen, DOJ would simply amend the regulations within which the Fourth and the Seventh Circuits this summer have found the source of the aforementioned authority. Moreover, the proposal would clarify that under those regulations, the Attorney General is withdrawing, with limited exceptions, the delegation of his authority to the board to sua sponte, reopen or reconsider decisions, and for the BIA to certify decisions to itself on its own motion. Moreover, the proposal also withdraws the delegation of the AG's authority for immigration judges to reopen or reconsider decisions sua sponte, subject to a limited exception. And this is a dramatic change in the law. Next, the proposals would allow immigration judges to certify BIA decisions reopening or remanding proceedings for further review by the EOIR director, a politically appointed manager, in situations where the trial level immigration judge alleges that the BIA made an error. Now, in my years as an immigration judge, there were times when I thought there were errors, but then to send it to the director for review, this proposal asserts that it's too cumbersome and time-consuming. That's the language that's used, to rely on the current legal process through subsequent motions by the parties. So instead, the proposal suggests that the process default to the politically motivated director. To make matters worse, and even more subject to the political winds, once an appeal has been pending for 335 days, which will occur much more frequently than the regulations suggest, all such appeals are to be referred to the EOIR director for adjudication. This opening for default adjudication, default decision-making by the politicized director, who is not a judge in any sense, all supposedly in the name of speed and timeliness, is both inappropriate for a quasi-judicial process and is ripe for abuse. The director will be a panel of one. Now, where does that ring a bell? Just like the Attorney General in cases he has certified to himself. Will the director be able to designate any of his adjudicated cases as precedents? This is just bad policy that is designed over time to further shape the ideological direction of decision-making by both IJs and the board. Moreover, this aspect of the new regulations is undoubtedly driven, again, by forces from above, with origins within the Stephen Miller Corps of Advisors. An additional change proposed by this regulation would, in most cases, establish a standardized simultaneous briefing schedule of 21 days, with just 14 days extensions possible. Of course, what this means is that neither party will have an opportunity to review and respond to each other's arguments. The proposal would also end the BIA practice of remanding solely for background checks, or because the IJ did not provide proper voluntary departure advisals. The BIA would now be authorized to issue dispositive decisions, including decisions on voluntary departure. But here's what's troubling. The proposal would also limit the BIA's authority to consider new evidence on appeal, or more importantly, to grant motions to remand for consideration of new evidence, except in cases where there is new evidence or information obtained as a result of identity, law enforcement, or security investigations or examinations, or where the new information raises a question of jurisdiction or removability. The proposal further instructs that the BIA may affirm a decision based on any reason contained in the record, and clarifies that there is no totality of the circumstances standard of review. Reversing years of well-settled law, the proposed regulation, quote, clarifies that the BIA may limit or qualify the scope of a remand while simultaneously divesting itself of jurisdiction over this case. This reverses matter of Patel from 1978, and in my circuit, Johnson v. Ashcroft and other cases. Thus, for example, if the BIA were to limit the scope of remand for further proceedings relative to a particular relief application, and respondent became eligible to seek alternative relief, for example, as a result of a bona fide marriage to a U.S. citizen, that would not be possible under the new regulation a subsequent modified order from the board. While these and other portions of the massive rewrite of BIA appellate procedure are purportedly designed with speed and efficiency in mind, their overall intent is clearly, again, to restrict and reduce immigration benefits under the watchful eye of the Attorney General and his chief surrogate within EOIR management, namely the director. Likewise, it is a political strategy that is perfectly willing to amend or withdraw regulations should federal circuits interpret them in a manner that expands the authority of IJs or the BIA, as in the cases of the Fourth and Seventh Circuits this summer. COVID-19 challenges safety, diminished due process, and the lack of transparency. On June 15, 2020, AILA, the American Immigration Council, and several NGOs wrote to EOIR Director McHenry urging him to reverse the decision to resume non-detained hearings as premature in light of the national public health emergency and the impact such resumption would have on the health and safety of the community, as well as the fundamental fairness of court proceedings. At minimum, a moratorium on in absentia orders was advocated, along with ongoing and open communications with stakeholders and dialogue with the public in order to mitigate harm and uphold due process. Thereafter, acknowledging the above letter, 12 Democratic senators led by Senator Elizabeth Warren from Massachusetts likewise wrote to Director McHenry, questioning him about the wisdom of such actions in restarting hearings in light of the COVID increase across the country. The senators noted that EOIR first announced several openings via Twitter, and then days later, Director McHenry issued a memorandum updating the office's practices. The director, in attempting to minimize the consequences of this and the risks associated with his decision, described the mitigating tools that IJs have, such as waiving the presence of represented aliens, granting continuances that have been more restrictive in terms of what's considered a good cause by the Attorney General, limiting attendance at hearings, or conducting hearings by telephone or video conference. The director further encouraged, if possible, the resolution of cases without hearings by written pleadings or joint or stipulated motions. Historically, it's been very difficult to get the Department of Homeland Security's ICE attorneys to stipulate to most anything in many jurisdictions. However, the senators nevertheless expressed concern that EOIR did not provide any details concerning how these decisions were and would be made in the future, and whether the agency had effectively weighed public health and due process considerations. In particular, the senator expressed further concern that EOIR would avoid repeating earlier mistakes that endangered individuals' health. Despite these expressed concerns, ignoring them through a notice dated July 1, 2020, EOIR continued to announce the resumption of hearings at additional immigration courts, including Philadelphia, where I served. The notice indicated that all persons in the court's public spaces must wear face coverings and become familiar with CDC information about COVID-19, providing, very courteously, a link to the reader. Without explaining how this would be enforced, the notice also listed those not permitted to enter EOIR space, such as those symptomatic, those exposed within 14 days, or diagnosed with the virus, even if asymptomatic. Lastly, the notice said that the option to file by email would end on September 6th. Nevertheless, despite these assurances and confidence by the agency, various sources continue to report that mask usage in immigration courts around the country varies widely. Moreover, recently, the GSA's Inspector General has found that building occupants are not being adequately notified if someone in a GSA-managed building has tested positive for the coronavirus. It also found that there are inadequate safeguards to ensure cleaning is being done in compliance with CDC standards. However, let's take a look at this on a practical level. The biggest challenge and the critically difficult choice attorneys must face in this environment is what to do about their individual hearings if motions to continue are denied and or the respondents want to go forward. What advice should attorneys give their clients about the potential health risks of appearing in person and testifying with emotion, perhaps for hours, through a mask, especially if utilizing an interpreter. And to make matters worse, via video conference into an adjacent courtroom, as is the model utilized in Philadelphia and apparently some other courts. At minimum, how will the respondent, the attorney, the DHS ICE attorney, and the interpreter, all wearing masks, maintain an appropriate social distance, effectively communicate with one another, and effectively communicate with the IJ? With those challenges, how complete and accurate a transcript will be generated? How will the attorneys and the IJ be able to police the quality and accuracy of the performance of the interpreter, who will not be able to observe the lips and facial expressions of the witness? How will the IJ be able to effectively evaluate the demeanor of the masked respondent? Will the attorneys, witnesses, and interpreter be permitted to periodically lower their masks to drink water? Will emotionally inevitable crying drenching the mask be permitted in immigration court as the lives of respondents and families are on the line? Well, we know, quite humorously, it is not permitted in baseball. See the movie A League of Our Own, Tom Hanks. You can all laugh now. Alternatively, perhaps the attorney and respondent will conclude that on balance, the personal risks to them and their families just outweigh the clear benefits of appearing in person. Under applicable regulations, as you know, the respondent may waive an in-person individual hearing and opt for one that is conducted telephonically. Most attorneys will strongly urge their clients not to exercise this waiver option and seek to continue their cases. But what if lives are in danger overseas, yet the respondent's health is compromised, making an in-person hearing problematic? As challenging and fundamentally unfair as the masked in-person or two-courtroom model may be, it's hard to imagine what a 5-person telephonic hearing would look like, although I know they are occurring right now, especially in detained courts. First, the masked attorney and respondent are likely to be together in the same room, and respondent, and then in most cases, there would be a contract interpreter who might very well be masked if he's sitting in the courtroom with the IJ, who would also be masked since face coverings are required in EOAR space. Then there would be the DHS ICE attorney, who may or may not be masked and would likely also request to appear telephonically. To complicate this approach even further, what if there's a telephonic fact or expert witness? I would not want to be the IJ managing such a scene and endeavoring with poise and patience to police the participants' compliance, particularly the interpreter for whom English might not be their first language, with the court's instructions. How does the IJ know if the interpreter is being understood? How are the attorney and respondent interacting? Of course, no one could be shown documents to identify. By default or design, telephonic individual hearings as suggested by the director, except in the simplest of cases, and or where the parties have agreed to broadly stipulate to a wide array of facts, are fundamentally unfair at their core. No matter how DOJ, EOAR tries to present and spin the premature reopening of non-detained immigration courts as a COVID-19 driven national public health emergency continues to rage, expand in some states, and explode well beyond the small embers described by our president, one thing is being made clear. Immigration courts now operate such that fundamental fairness and impartiality are diminished. Safety is secondary to expediency, and transparency in decision-making is absent. Immigration courts have become mere weaponized political tools in the arsenal of the nationalist leadership of our nation. So with all this, I had to decide whether to retire, when to retire, and here's my decision, which I call a return to advocacy in support of due process. Despite turning 70 in June of 2019, I had intended to serve as an immigration judge for perhaps at least a few more years. I certainly did not want to be replaced by this administration. But then there was the evolving political climate that we've talked about, unrealistic docket pressures, the lack of concern for meaningful due process, the Attorney General's expansive use of his regulatory authority to rewrite precedents, thus continuing the transformation of the BIA, always at risk for undue political influence as a creature of regulation under the thumb of any Attorney General, toward becoming what I described and been quoted as saying to be a Politburo-like rubber stamp. Perhaps that's an extreme comment, but I think that's really the goal of the Stephen Miller crowd. Regulations drafted specifically to limit or eliminate immigration benefits and virtually eliminate most of the protections afforded to those fleeing persecution and violence of all forms. And lastly, the continuing effort to decertify the National Association of Immigration Judges as a legal collective bargaining unit to speak and negotiate on behalf of immigration judges such as myself and others, a status NAIJ has held consistent with the National Labor Relations Board regulations since 1979. All of these forces and factors, I regret, ultimately tipped the balance for me, and so it was time for Courtroom 1 at the Philadelphia Immigration Court to go dark, and for me to transition to a period in my life of advocacy, teaching, and speaking to individuals like you and others in advocating professionalism and excellence on behalf of your clients. So I want to thank you all for participating today and for your patient consideration of my reflections and insights. And after just a short break, I'll take your questions, or maybe just now. I don't know that I need a break. And thank you again to DocketWise and James Pittman for giving me this opportunity to hopefully contribute and to enrich your perspective on these issues. James?
Charles, thanks so much. That was wonderful and extremely informative. Very, very interesting and informative. And we do have a number of questions. If you're fine to go ahead right now, I'll just proceed in with the questions.
Yeah, you know what? Let me just take a quick break and I'll be right back.
Okay, let's give Charles a minute. And everyone, please, if you have any questions or comments, please post them in the Ask a Question feature. If there's any other topic you think you'd like Charles to address right at this point, now is the time to do that. The recording of today's webinar will be available soon after the conclusion of the live event. It takes a little bit of time for it to be formatted, and then it will be available on the same page where you logged into today's webinar. So if there were any friends who couldn't attend, please do share the link to the page with them. We'll just pause for 1 minute until Charles returns.
Okay, James, I'm back now.
All right, we are back, and let's now take the questions. So the first question asks, what can the Immigration Judges Union do to try to maintain its independence under the current structure of immigration courts? Is there anything more than the union has already done, or have these avenues really been exhausted?
Well, it sort of begs the question of whether or not the immigration judges were ever really truly independent, and they were not. But throughout our history, there has been only one other instance during President Bush, George W. Bush, where during the period of Attorney Generals Ashcroft and Gonzalez, that there was significant political intervention. So what happened was the regional director of the Federal Labor Relations Authority, FLRA, heard the case. There was a petition for decertification filed by Department of Justice. Department of Justice lost, and there's so the decision was that the union would not be decertified. But last Friday, I believe, right before Labor Day, on the same day that Director McHenry sent an email to all the judges wishing them a happy Labor Day and thanking them for their hard work, the government filed an appeal to the full Federal Labor Relations Authority. So the full board will hear that. this happened once before in the year 2000, perhaps somewhat surprisingly to some, within the end of the Clinton administration. There were forces, and there's always forces within the government that opposed public sector unions, and they tried the same thing and lost. So I'm optimistic that the arguments that they're making, given what I know from our president, Judge Tabador in Los Angeles, and others, that it's not likely to be successful. I think this administration thought that perhaps because of changing political winds and the compositions of the administrative authority that they could prevail or even prevail in court. So I don't think that we're going to be decertified, but despite that, because of the structural flaws, which I mentioned, there's a limit to what the union can do other than file grievances and making a request to bargain under labor law on certain issues, such as the quotas and how they're implemented. So I'm not optimistic that without structural change that there will be much of a difference under this administration. But of course, this begs the question of the election, because I do not think under a Biden administration, despite what I said about the decertification effort at the end of the Clinton term, that there will be this type of pressure on immigration judges politically, such as what happened to one of my colleagues in Philadelphia, where the attorney general didn't like one of his decisions that had originally came back from the AG's office, and he was removed from the case, and 80 cases were taken away from him in a similar vein. So I don't think that would happen under a new administration. So we need structural change in the long term, but right now I think we need political change, and I believe that there'll be a reversal of many of the regulations. Any regulation, and I can't give you a citation, any regulation that was published in final form within 6 months of a change in administrations can be reversed. And I don't know the procedure, but I understand it can be done fairly seamlessly, and that's what I expect will happen.
Very good. Some advocates suggest that we will be entering another phase, such as when the AG previously packed the BIA during the Bush years, in which the immigration bar needs to expect losses at the IJ level and the board, and must plan to fight at the circuit court level. Do you think this is accurate? And if so, how do you think that will change practice before the immigration court? Do you have any suggestions for advocates who primarily practice at the immigration court level rather than the circuit level?
Well, because of the 2002 regulation, in 2002, everything changed. We went to a period of summary affirmances, but what also changed was that immigration judges' decisions, the factual findings, are subject to clearly erroneous review, and that resulted in the explosion of jurisprudence. Early on in my career, which began in the early 80s as a private practitioner, I didn't even read many circuit court decisions each year. There wasn't that much circuit court litigation. There was some in a few areas of the country and in a few areas of the law, but I think that we're already in that era where you have to prepare for going to circuit court in many cases. Now, you're going to know in some cases they're not going to be disputed, or it's going to be one you're going to prevail on. But what I've always advised at CLEs is that you prepare every case as if it's going to the circuit court, and you also get to know who the judge is and what their proclivities are, and that you make sure you put in the record even arguments that are beyond the jurisdiction of the IJ. So when I was an immigration judge, there were times when either it would be presented to me as a request for a good faith modification of existing law, even if I didn't feel that I could distinguish the arguments they were making against current law that bound me. And so there were times when on my own, I would place dicta in decisions that effectively were a wink to the circuit court beyond the board to perhaps they should take a look at this issue. So you do have to prepare to litigate. A great example of that was originally when the arriving alien regulation was first published, it proscribed applicants from applying for adjustment of status. And litigation ultimately turned the tide, first in the First Circuit in the Succar case, SUCCAR. And in that case, they found that the regulation was ultra vires. It was inconsistent with the intent of Congress. So ultimately, the government caved and redid the regulation and allowed for adjustment of status, although still disqualifying immigration judges, but at least allowing CIS applications. So I would say that you have to think about whether there's an issue that is going to be in dispute, that the board is going to concur with DHS on, and prepare for circuit court. So many people now are really becoming versed and qualified to file petitions for review. I have to be honest, I was not involved with much federal litigation during my years of practice, but I now think that everyone has to be, or be prepared to go co-counsel with someone who's more comfortable with that litigation in the federal courts.
Very good. All right. Now, let's see here. If there is a change in the administration after this coming election, how long do you think it will take for our immigration court system to fully recover?
It's like, how long will it take the economy to recover? I don't know. I think that a lot depends on what priorities are given to rolling back regulations, and the regulatory changes can be accomplished fairly quickly. I don't really have a crystal ball, but clearly whether there's going to be any major statutory changes will depend on the composition of the Senate, and beyond the majority, whether or not the filibuster remains and the 60-vote rule remains. So I don't really know. I'm hopeful that there will be reform and changes and opportunities to strike a balance. And that's not to say that I believe that everyone applying for a benefit should get a benefit, although perhaps I had higher grant rates than the average. There were certainly many instances where individuals were not entitled to benefits or withdrew certain applications after having dialogue with me, and after their attorneys and I had a dialogue about what the probabilities of success were. So I'm hopeful. I don't know how long it will take, though.
All right. After watching a documentary about ICE and immigration on Netflix, the questioner asks, they're worried about the immigration judges no longer following their oaths. Rather, they follow the requirements of the administration. What chance do you see to change it?
Well, I mean, you say not following their oaths. I mean, I had an oath to follow the law, and the law would be the statute implementing regulations and the case law. And if there was a gap within the scope of what, beyond statutory eligibility, the exercise of discretion. As I mentioned early on in my immigration practice, there were so many gaps in the law, and there still are. So follow my oaths. Well, I took an oath very similar to what the president takes to support and defend the Constitution and against all enemies, foreign and domestic. And so I don't really know about making a judgment about oaths. I think you're always going to find a variation in interpreting the law, much like you did at the Supreme Court. I mean, look at the relationship between Justice Ginsburg and Justice Scalia, who were very good friends, who had very different interpretations of the law. But periodically, Justice Scalia and Ginsburg. Justice Scalia would end up being in alliance and in a different configuration in a particular decision because he wasn't in some ways driven by emotionally laden ideology. I mean, he did sound that way in some cases, but I can remember a particular case involving whether someone had a reasonable expectation of privacy. The case involved a helicopter and infrared technology being able to determine that an individual was growing pot plants in their house. And Justice Scalia ended up siding with, quote, the liberals in concluding that the individual had a reasonable expectation of privacy in their homes, such that that level of intrusion was unconstitutional. So I don't really know that you can say that someone doesn't follow their oaths. I think that people, I always wanted to not be somebody at the tail of the spectrum, and to be an individual who would neither be granting every case or denying every case. And one of the things I did was I didn't keep a record of what was happening with my cases. I know some judges that kept copious records of trends in their cases, and I have to say quite proudly that when the performance metrics went into effect and we had this what's called a dashboard with all the different criteria that we were supposed to look at, I looked at it at the beginning, and I looked at it 1 or 2 weeks before I retired, and I never looked at it in between. I just refused. I figured I'm going to do the best I can, and if they don't like it, I'll fight it in grievance.
Well, Charles, before we get off that, if I can just ask you to go into a little more detail about those metrics, because I was curious about that. I mean, what were some of the metrics, and how strictly did they enforce them, and how, I mean, I know you said you didn't look at, but what was your sense of how diligently other judges were trying to follow them, and did they come down on people if they didn't meet them?
Well, I think that because they were so new, remember they went into effect October 1, 2018. And then in the first quarter of 2019, we had the furlough. So I think that there are judges who perhaps had a history of not being quite as productive, having a lot of reserved decisions. I can't say for sure what was going on behind the scenes, but I can tell you that some of the metrics had to do with how, and you had to meet like 2 out of 3 or 3 out of 4 criteria. So one of the ones that made the biggest press was completing 700 cases a year, a one-size-fits-all number, regardless of the court you were in, the type of cases you were in. They came up with that number looking at all of the cases combined across many courts. But in many cases, especially if you include detained cases, you have individuals who take orders regularly and don't litigate their cases. So, and the first year, I believe that I had, I guess this doesn't violate any non-disclosure agreement, I think I had somewhere between 550 and 600 cases, but they had scaled down what the expectations were because of the furlough, and I was a little bit under. But I think that the goal over time was to create anxiety and intimidate, and to really encourage people to take a look at whether they would grant a continuance or not. I mean, this was really driven a lot by continuances, and the tension between due process and continuance. You might have a case that's been around for a long time and it's moving in one direction, but then there's a criminal charge pending, or then the individual marries a U.S. citizen and it's bona fide. Or maybe they go from a lawyer number 1 to lawyer number 2, and there's a Lozado ineffective assistance issue. And maybe there's an issue the government misses. And, so there are so many reasons why many of my cases took a long time. And so my goal was to get it right at the back end and not worry about how long it took. On the other hand, there were people who would abuse what they might have thought was my view to be fairly open and expansive in terms of good cause and continuances. And, if somebody didn't give me a reason that made any sense, I would deny the continuance, or I would, if it was too old a case, I would try to switch it with something else and not have it go to the back end of my docket. So I think the goal is to make people vigilant, but more than that, but to try to get the cases moving more quickly. And of course, if many of these regulations become effective and finalized and don't get reversed, you're going to have a lot of people doing pre-termissions and having their completion rates go way up. So I didn't need that to be a professional. I have to say that just like the ideology there's a scope of interpretations of the law. You're going to find some judges that are more productive than others for reasons that are justified and sometimes not justified.
Next question. Let's see here. What were the major ways in which the administration's policy preferences were demonstrated by ICE TAs in their conduct during removal proceedings? So how did the TAs, how did you observe the TAs' handling of these hearings change as a result of the administration?
Well, that sort of, again, begs the question of where you are in the country. So I was in Philadelphia, doing Philadelphia non-detained, Pittsburgh televideo, and then I did detail assignments to prisons and other non-detained cities. So a lot depends on the leadership through the chief and deputy chief of counsel in a particular city. But what I would say over the years, I think ICE viewed me, and I can only speak for me, as having a level of credibility and decisions that were pretty well formulated and very solid. And the chief counsel once told me, he said, Judge Honeyman, we don't appeal very many of your cases unless there's really some important issue of law. And I would say over many of my years of experience as an IJ, there were not that many cases appealed. But when they were, there was a really good reason. I mean, on the government side. So what really happened, I think, during this administration is that, of course, administrative closure ends, and you have government attorneys, and again, just like judges, some had a more restrictive view and interpretation of law than others. But I'd say across the board, there were more appeals reserved than there were before this administration. Sometimes that meant the appeals were actually filed. I would say, in the particular social group area, there was a tremendous upswing in the number of cases filed. And I think that some of the government attorneys would admit to me privately that they weren't happy about what their position had to be or the interpretation of the law they had to take. And some of them, I think in close call cases over the years, maybe because of my reputation or otherwise, the government's attorneys would sometimes go down and speak to what they called management, meaning the chief or deputy chief counsel or senior counsel about whether they should reserve appeal on a grant that I was going to issue. And that was less and less true in the last 2 years of my being on the bench, where they just knew that there was no way that the government would agree to a grant. And some of them were I had enough of a relationship with where they would basically tell me, listen, I'm going to reserve appeal, but don't expect the one will actually be filed. So I know that this varies tremendously around the country, but I would say, I think a fair assumption is that there was pressure from the top, just like I mentioned in the appointment of the ICE principal legal advisor to the board, and what admonitions he was giving to his trial attorneys to take a more restrictive position. And I think that was probably true nationally, with greater and lesser degrees of that being manifested from district to district.
Next question is, what are the actual procedures for setting up an Article I court? How does that actually have to happen? And how can the public help to make that happen?
Well, the public can make that happen by voting and participating and writing, talking to their members of Congress. I have a whole file on this. It's somewhat complicated. There's different models of it. The one model that I can speak a little bit about that I think NAIJ is mostly supportive of is the Federal Bar Association created a model with an actual statute and the specifics of how it would work. And as I understand it, there would be grandfathering for incumbent judges for some period of time, and there would be it would have to be a statute that passed this, and I believe that there would be political appointments to the appellate under this model to the appellate level, and there would be, like analogous to the Board of Immigration Appeals under this model, but that the trial level immigration judges would be purely merit-based. So I think the idea of that would be, as administrations change, there would be, just like with federal district court judges, there would be political appointees at the appellate level, but the trial level would be not be politicized. And it would also mean, as I described in my remarks, that once the trial level Article I judges were appointed, I believe they'd be appointed for renewable terms. It might have been 15 years, I'm not sure. And that there would be a firewall. There would be nobody taking cases away from them. There would not be anything like the Attorney General's certification authority. And that would, the particulars of how it would be implemented and over what time, I would say the more important issue is one of political turf. Historically, there has been, I think, some resistance because both administrations, because under the statute, the Attorney General and the executive branch has plenary power under Supreme Court decisions over case law. So I think that the question is, are you willing to give up your turf to get these appellate political appointments and have a fundamentally fair hearing? So how you persuade people to move in that direction. I can tell you there does appear to be a growing number of those in the political class are supportive of it. So I guess that's about all I have to say about it.
All right. Next question. Is there a broad due process challenge to the way that EOIR communicates with the respondents? For example, court closures versus last-minute emails to elicit.
What did you say? You got cut off a second there.
Oh, I was saying, is there a broad due process challenge to the way that EOIR communicates with respondents?
Meaning, you said last-minute changes in hearing dates? Is that it?
Yes. Court closures via last-minute emails to a listserv and via Twitter, like telling people about the court closing on Twitter, that sort of thing. Do you see due process issues in there abroad?
Well, I think where due process issues would come up is if someone got a last-minute notice and their continuance was denied. And, I don't, there's a question of fairness if you create a defect in the record because you can't be prepared. So let's say, for example, you're not doing master calendar hearings like in Philadelphia and other places that have reopened, unlike Newark that's doing them, and there's a lawsuit to try to close the Newark court because of the outbreaks. But you could have the court want to move a case from 2022 into a master calendar in a month, and you were not counting on having that small amount of lead time for preparing. So I think it's again about making a record, and but I don't think there's any interlocutory measure. I mean, you can. This Board of Immigration Appeals, I don't think is going to favorably grant an interlocutory appeal reversing a denied continuance motion. So I think there's making the record and using the Bar Association, the press effectively, but there's no body of law other than. I guess in theory, you could take a denied interlocutory motion to continue and file a declaratory judgment action in district court. But I just don't think that that's going to be a successful measure. I think one of the things that people do is file motions to, and I'm sure your users and others here know this, to switch cases. If you have a case coming up and you're not ready for it, as long as the government has enough time to get the file, to try to switch it out with somebody. If you have a case in 2 years, it's a great cancellation case, you want to bring it in. And so the ALO listserv around the country has people doing that all the time. And I think most judges are amenable to that. Some are not. And of course, you have to make sure the government has enough time to get its file. So there are ways short of litigation to try to work with that. It's all disappointing when this happens at the last minute. One little anecdote, and I don't know the answer to this, but I participated in 2 NAIJ Zoom town hall meetings. And what I learned, I think, from one of them and perhaps another meeting, is that when asked about who decides whether to reopen a court, I think that the agency was saying that they were getting input from, or that this was a decision made by the U.S. Attorney's Office. And somewhere, it might have been in Newark, there was a dialogue with the U.S. Attorney's Office that said they knew nothing about that authority that they had, or input, or effective decision making. So I don't know how these decisions are made, but I suspect that there's a collaboration between political appointees and the managers, such as the EOIR director. And maybe they were saying the U.S. Attorney's Office was involved as window dressing, even if they weren't really the primary decision maker. So I don't know, but it's not making me very comfortable to have to even say that.
And I wanted to ask you a question to comment on this dispute that occurred. I'm sure you heard of it. It was the case of Jorge Baez Sanchez, where basically the Seventh Circuit had to admonish the BIA. The BIA sort of refused to implement the Seventh Circuit's decision. This had to do. Do you know the one I'm talking about?
They admonished them, and they basically said it's as if we don't exist as a court. You're ignoring a federal order. This was to the BIA when they got the case on remand or something. Was that it?
That's right. The IJ allowed the respondent to apply for a waiver of inadmissibility on a criminal ground in order to apply for a U visa. And then the BIA said that basically only the Secretary of Homeland Security has the authority to decide whether the respondent can apply for that type of waiver. And then the respondent appealed to the Seventh Circuit. In the meantime, while they had the case on appeal waiting to be heard by the Seventh Circuit, the Attorney General wrote a letter after the fact, wrote a memorandum, basically in a footnote saying that authority resides with the Secretary of Homeland Security. And then the Seventh Circuit came down on the respondent's side, and the BIA essentially ignored the Seventh Circuit and cited a footnote in the letter by the Attorney General. That was unbelievable.
It's pretty outrageous. He was applying for a U visa and a crime waiver.
Yes.
As a matter of discretion. Yeah, I mean, that was outrageous. I mean, look what they're doing now with the appellate regulation, which was specifically formulated to reverse the Fourth and Seventh Circuit's decision on Castro-Tum, administrative closure. I think that the question is whether or not you would ever have a circuit court attempting to sanction a federal official for ignoring their order. We're in uncharted waters here with so much from this administration that I don't think many legal minds have anticipated they would have to think about these issues. We thought that, under Marbury Madison and other well-settled case law, that there's a hierarchy of decision-making and deference to decisions. And that's why the certification authority is just so ridiculous. I mean, historically, there was a very famous case, matter of Gene. It was the baby shaking case that I believe Attorney General Ashcroft, took certification on. And so I can understand how in rare circumstances, if we don't get an independent court, that might be appropriate. If there's some, dramatic mistake that they think that the court, that the board has made. But look at matter of ARCG. I mean, they're reversing ARCG by saying, well, there was no really analysis. There was just a stipulation. There was just an agreement. Well, there was an agreement because the DHS civil prosecutors agreed that under narrow circumstances, there could be a cognizable particular social group. And they put that in their brief as long ago as 2004. So it's the problem with having the EOIR in the Justice Department and the current structure is that there's no firewall to create disincentives for political abuse of the structure. And this administration has shown that it could happen. And to me, the argument to the Republicans is, you may get, a President Sanders someday or somebody like that who's going to have a view that's dramatically opposed to yours. And you've got, you have an immigration court where his attorney general can just rewrite some case law that his administration doesn't like. So, it's not just a left-right issue. And I think that's how it has to be presented. And I know that NAIJ and others have been on the Hill, and there are others who are now openly more in supportive of an article on court. People didn't know what it was, didn't understand that this was a potential issue because the political class was behaving. And now they're not behaving in a dramatic way. So you get people in Congress willing to take a position on it. So I don't know whether it'll happen, but the case you mentioned was among the most outrageous cases that I've ever read in any circuit court decision.
Absolutely.
That comes of it.
Yes. Okay, we have just enough time for the last two questions that were posted. And the first of those two says, you were an immigration judge before the year 2003 and after 2003, which was prior to and then after the creation of the Department of Homeland Security. Did you notice a difference in the conduct of the hearings and the conduct of the administration when the TAs were moved to DHS from DOJ, where they used to be prior to that change? Did you notice any other differences after the abolition or abolishment of the INS?
I really didn't notice any difference in conduct. Again, in the Ashcroft Gonzalez era, there was some different positions on specific legal issues, but not really in terms of conduct. I think one of the ironies of the change, the goal was that the INS was considered this kind of mixed up agency with different components, and there was not seamless communication. And then you create the Department of Homeland Security with Customs and Border Patrol and CIS and in HSI investigations. So you have these different balkanized components. And so I would say one of the things that happened is there was an increase in the government not being able to have its file available for the hearing. That was one of the ironic increases. And as the volume went up in many parts of the country, they didn't keep the files locally. They're at remote storage centers, I believe in Missouri is one of them. So not so much conduct, but there was no improvement in bureaucratic management efficiency.
Okay. And then our last question says, under the current administration, how likely is it to reopen a case that has a final removal order?
Well, I mean, there's so many, as a pretty generic, which how likely under this administration, well, it depends on the context. I mean, if the person failed to show, you have to look at notice and whether there's any, changed circumstances. What was the reason why they failed to appear? But one of the things that can change if this administration, these regulations that I mentioned earlier, I believe that they want to put them in final form regardless of the comments before the election. So you're going to have situations where if it's more than 90 days from the order and you don't have a good notice argument and you don't have a great change circumstances in an asylum context and you can't get a joint agreement by the government to reopen the case, many times I might have a situation that was compelling that I would reopen sua sponte under a matter of JJ and the exceptional circumstances standard. And if these regulations become final, IJs will not have that authority. So I think that the direction of the regulations and eliminating sua sponte authority of the IJs will be significant under this administration. But it really depends on the context. I mean, and it depends on who the judge was too. And you might have a motion to reopen that is not to reopen a case that's not too old. So the judge might not be retired. It might be the same judge that will hear the motion. So there's really a lot of answers to that. But I would say the biggest problem right now is the packing problem. Is that they're having people be appointed who they think will have an ideological predisposition to interpret the law in a certain way because they come more from prosecutorial experience rather than from academia, NGOs, or private practice. But of course, that's not always the case. There were many trial attorneys who became IJs over the years who I found were fair and reasonable, and perhaps not the same grant rates in some categories. But it's be careful what you wish for, and I would cite Chief Justice Roberts for that proposition.
All right. Well, those are all the questions that we had and all the questions we have time for. So I want to thank everybody for tuning into today's webinar. Once again, a recording of today's webinar will be available on the same page where you joined today's event shortly after the conclusion, after we go offline here. If you have suggestions or comments for any additional topics for webinars that you'd like to see, please do feel free to email those suggestions to us, team@docketwise.com. And everyone, have a wonderful day, and please stay.
Let me just as a final comment, I just want to again thank DocketWise and James for the opportunity. I thank you all for your participation and attention. Again, as I was speaking to James before this ended, it's a little different when you don't have eye contact or get the emotional reaction, especially if you try to throw a bit of humor in there, like I did today. But I wish you all the best, and hope that you will continue to fight for due process and zealous representation of your clients. And I hope to see some of you in different contexts. So thank you very much again.
Thank you, everyone. Stay safe and take care. Goodbye now.